Good afternoon, distinguished panelists, colleagues, stakeholders, and invited guests. For those who do not know me, I am Sadera Shaw, Deputy Chairman for the IDT Western Division. This session's theme examining and critiquing the IDT's procedures and approach to industrial disputes goes to the core of our mandate and the trust placed in us. The IDT exists not only to resolve disputes, but to do so with impartiality, transparency, and fairness. Fairness, however, is not a static concept. It must be continuously tested, measured, and where necessary, refined. Our procedures, how we hear matters, evaluate evidence, manage timelines, and deliver decisions are the channels through which justice is either upheld or weakened. This session is not about fault finding, but strengthening. Institutions grow stronger when they examine themselves with honesty and humility. Constructive critique is not a threat to our credibility, it is the foundation of it. We are fortunate to have a diverse group of panelists, and I have been instructed to be very short. So I apologize if I miss out key points in your introduction. So our first panelist is Dr. Suzette Henry Campbell. Dr. Suzette Henry Campbell is a lecturer at the Mona School of Business and Management of the University of West Indies, Mona. Her journey has been one of great fulfillment, not only in her personal growth, but also a mental shift to understand nuanced worldviews and the tensions that exist, especially in today's chaotic environment. Thanks to her terminal degree from Nova Northeastern University in Florida, she has developed an appetite for systems thinking in the discipline of conflict analysis and resolution. She believes that cultural humility and conflict resolution as a skill are essential in resolving many of the hardened concerns when navigating conflict minefields in every sector. Her experience in a multinational environment, coupled with her work in the region, namely Trinidad and Tobago, as well as St. Lucia, has been illuminating and has broadened useful skills for the contemporary arena.
Thank you.
You're welcome.
Just a moment.
So I've been instructed to continue. So the second panelist would be my learned friend, Mr. Gavin Goff. Mr. Goff is the head of Myers, Fletcher, and Gordon Litigation Department. Over the last 2 decades, his practice has generally focused on employment law, public law, constitutional law, and tax. He has been involved in several landmark court decisions relating to unjustifiable dismissal. He is also well known for his advocacy concerning planning and development regulations and for successfully litigating the first class action suit against the government for the refund of traffic tickets. Thank you. For over 10 years, Mr. Goff tutored civil procedure and practice at the Norman Mandel Law School. His love for teaching was born from decades as a volunteer teaching math and English to adult learners in Kingston. In 2008, he co-founded Adult Learning Centers of Jamaica, a not-for-profit organization focused on improving adult literacy. Mr. Goff is a member of the Jamaican Bar Association, where he sits on the Employment Law Committee. He's a member of and former chairman of the advisory board of the Salvation Army Eastern Jamaica Division. He is also the honorary counsel to the British High Commissioner in Jamaica. Are we ready?
Yes. All right, thanks for the intro. So as I sat and I listened to the presentations, there were a number of themes that emerged that basically finished my presentation. But I wanted to start by looking at what a tension or conflict is and the fact that these are aspirations that cannot be achieved simultaneously, right? So let's bake that in. Now, in looking at the IDT, as the legal framework that establishes responsible for resolving industrial disputes through arbitration with broad discretion over procedure and relief, right? So let's make the story begins there. Notable advantages exist, and they have been expressed in earlier presentations, and I'm sure they'll emerge again through the conversations here. But accessible dispute resolution outside of the ordinary courts come to mind. Speed, no, we have a question sign where that is concerned, no. And cost effectiveness. Specialized labor relations expertise. Expanded access for non-unionized workers, 2010. Flexible procedures and tailored remedies. And all of these, including others that may remain unnamed, contribute to this industrial harmony that is in pursuit of our national interests. Another set of notable advantages: expanded access by non-unionized workers in 2010. The amendment also made it possible for non-unionized workers to have direct access, rewrites disputes, a reduced need for industrial action, and in some jurisdictions, has not happened here in terms of my research, solidarity in industrial action. I may be corrected. Flexibility in crafting and tailoring those remedies. Bakes in the importance of due process, natural justice, procedural fairness, and reasonableness. Now, my presentation is going to be anchored to that point in terms of critiquing the IDT. There are a number of observations made by persons who have utilized it. Sometimes it's in the case of the employers, where there's a challenge on a point of law. On a point of law, the opportunity exists to move it or to be challenged in other spaces, Supreme Court going up to the Privy Council. The critique I'd like to continue with is that when we talk about the IDT and its reach, there's broad and economically harsh remedies, and it has been mentioned before that small businesses are typically impacted. It has a broad discretion to order compensation or reinstatement, among other remedies. There's no clear statutory cap or financial impact assessment, and this I retrieved from Duncox, where on the other side of that ledger, the questions emerge. Yes, we're doing well in terms of ensuring that companies, organizations understand that procedures are important. We're also baking in the idea, if there are standards, then the standards mean that you're moving, let's say, from 1 through to 5, then it's consistent in terms of its practice. While making justice accessible to workers, one area of concern is the need for procedural safeguards. For example, strict adherence to rules of evidence, cross-examination, and clear reasoning, which was an observation made by the Supreme Court, even after it agreed with the outcome, the award that was made by the IDT. Looking at the case, Island Jamaica Limited versus the Industrial Dispute Tribunal, the judicial review cited the following: unjustifiable dismissal wasn't challenged. Compensatory award was challenged for being Wensbury unreasonable. And the failure of the IDT to take into consideration all relevant factors, parity with previous awards absent from findings and not considered, and therefore the award was viewed as being irrational. Just a note on Wensbury unreasonableness, just to have an idea of what that concept means. There's grounds for judicial review because there is a question of the outcome, the award that is given. Concept of relevant consideration. Concept of irrationality. If it is considered irrational, if no reasonable person acting reasonably could have come to that decision. And this dates back to a case in 1948, the Associated Provincial Picture Houses Limited versus Wensbury Corporation. Summary of critiques continue. Though the courts have upheld a number of awards by the IDT, there is the suggestion it is the master of its own procedure. Employers and claimants are of the view that hearings are sometimes unbalanced and insufficiently rigorous. The IDT can make awards that are compensatory, even though the Act is silent on this kind of power. Further critique suggests that the IDT's responses as a quasi-judicial body appear to extend outside of the bounds of statutory framework, triggering appeals, error of law, or unreasonable outcomes. The IDT comes under scrutiny where critics suggest thoroughness is sometimes sacrificed for speed in closing cases. The result, awards fail to adequately engage with all evidence or to explain why prior awards were followed, and this undermines legal confidence. Section 12.4c of the El Rido makes the IDT award final and conclusive except on a point of law. Critics are of the view that errors of fact may escape correction unless a clear legal error can be identified. Questions of this nature emerge. Is the procedure fair? Though the IDT has wide discretion, what mechanism or mechanisms exist to ensure there is no procedural impropriety? And judicial review of the awards help to ventilate and resolve the tensions that are likely to come where there is discontent regarding the outcome. The final critique I have, the IDT is staffed by, not able to even read that. Yes, by lay members, labor and management, and they do bring to the arena a level of expertise from many years of practice, but there may be fault lines in legal reasoning and consistency. And the other is backlog, constraints, and high expectations from unions and employers lead critics to argue that the current procedures favor process over principle and dispute resolution over systemic reform of labor relations. So it ties back into the conversations that were had before, the different presentations, in that if we're going to look at reform, there are these gaps or fault lines that have to be examined. And social dialogue provides for that backdrop, that background, to enhance the El Rider, as was done in 2010, look at the statutory limitations on remedies, transparent guidelines relating to the awards that are given, procedural and efficiency improvements, case management rules, timelines for hearings. Earlier it was 21 days to have an outcome. Now, in today's society with access by the non-unionized workers, that may not be practicable. ongoing legal training, certification of lay members. That's perhaps where the support of folks from the legal arena would be able to support. Resource allocation and oversight, and the current modernization, digital archiving of cases for access. All right? Thank you.
Afternoon. Good afternoon, good people, and Lambert Brown. Forgive me, I had to stand because the AC blowing right on my head and I can't take it over there. You know, it's my honor to be here. Thank you for inviting me to speak. You know, I think it was in the Godfather, Michael Corleone said that you should keep your friends close and your enemies closer. Well, I don't know which category I fall in, but I'm glad to be here as a friend to the Tribunal. So, if you could just bring up my presentation, I have just 3 pillars that I want to speak about today, and I don't even think I'm going to use up the whole 10 minutes. It's briefly called Updating the IDT's Rule Book. Now, if you've seen the IDT's rules, they're typewritten, so you know that is a long time. And it is a good time now, 50 years later, for us to look at how we can improve things, because even the courts have rewritten their rule book over 20 years ago. And there's no reason why the IDT shouldn't also be looking at improving and modernizing its processes. I didn't get the tutorial. I was going to press this green button. Okay, thank you. So, pillar number 1, the IDT needs to be faster, right? Now, we've already heard about the 21-day period. Actually, it has never been met. That 21-day standard has never been met in 50 years. It's impossible to meet. And it probably always was impossible to meet it. But the point is that the IDT was created to be faster than the courts. So there's no reason why we should be having 50 sittings before the IDT when the average court case takes 1 to 3 days now. 1 to 3 days. Not to say that it gets heard within 1 to 3 days, but in terms of the actual time that you spend in the courtroom, 1 to 3 days is what you get. So what did the courts do to improve and make their system faster now that people are actually wondering if I should go to court instead of going to the IDT? The first thing they did was case management, right? Case management simply means that before we actually get into the meat of the matter, we sit down and see how can we efficiently use the time here. So it means setting deadlines, time frames for things to be done, to be exchanged, and we set how long, how many witnesses you're going to call, how much time we need to allocate to this case, and we schedule it in advance. Now, case management has completely revolutionized, just this one thing has completely revolutionized the Supreme Court system, because it wasn't always part of their system, no. And case management, it started in the civil system, it's actually moved into the criminal law system, specifically to address the backlog there as well. Briefs. The current system is that briefs are exchanged and they're not even mandatory. But that's a problem, because the role that the briefs play is so important that, one, it should be mandatory in my opinion, first and foremost, and two, it shouldn't be something that's exchanged. Because in every other adversarial system, and unfortunately this is also an adversarial system, in every other adversarial system, there's one party who brings the other party before the tribunal or the court and says, this is the problem I'm having. And then the other party comes and says, well, I see this is the problem that you're having, this is my response to that. So having both parties exchange briefs isn't actually assisting the tribunal to understand what the dispute is. Because you have a situation now where you have one brief and the other brief, and neither one of them is talking to the other because they are being exchanged as opposed to being responsive to the one to the other. I actually had a case once where I was representing the company, and the aggrieved worker did not submit a brief. And of course, our position was, how can we open our case in a circumstance where we don't actually know what the aggrieved worker is saying? So to actually have a case where an aggrieved worker doesn't have to file a brief is not helping the system to be faster. And the third thing, and I would say if there's only one thing that the tribunal takes from what I have to say, witness statements. What's a witness statement? A witness statement simply means that instead of having somebody come and ask evidence in chief, you actually just simply have a statement that's prepared, and that statement goes in as their evidence in chief. That alone will save you weeks and weeks of time. And it will save our honorable stenotypists, I see a couple of them here. It will save them having to type out things which actually have already been typed out before. You can simply submit it, this is the statement. And then you can come and have cross-examination on that person's statement. That also has helped improve the efficiency in the Supreme Court system significantly and cut down delays and backlog. Second pillar, let's be fairer, folks, right? Disclosure. Disclosure is said to be one of the most important aspects of natural justice. So it's a little ironic that the body that is known most as the advocate for natural justice doesn't actually employ the key factor of natural justice being disclosure. So very often you come to the tribunal and you're seeing documents for the first time. And especially when you are going there representing an employer, that's particularly unfair because you've closed your case very often by the time you see some of the documents which are coming. And you don't have the opportunity to reopen your case to address these documents which were in some cases deliberately hidden from you. There's no reason why, as the master of its own processes, the tribunal cannot insist that documents be disclosed in a timely fashion and say that if you don't do that, if you don't do it, you can't rely on it. That also will cut down the amount of time that is spent arguing over things what people are taken by surprise by. Employers' remedies. Now, I heard already that, the IDT is a poor man's court. And I think that's probably part of the reason why we need to relook and rethink if the IDTs, some of the concerns which Wayne Chen and others have expressed, don't have some of their foundations in the inequity in the rule book itself. Let me say what I mean by that. I'm going to give you the example of the case, Marlon McLeod case. Some of you are familiar with Marlon McLeod case. Marlon McLeod case was a case which I had done where it was a case for unjustifiable suspension, not unjustifiable dismissal. And we had argued before the court and the Court of Appeal that, the IDTs, the LRIDA doesn't have anything in there that says that there's a remedy for unjustifiable suspension. And we said, applying conventional wisdom, that, the authorities all say that the tribunal as a creature of statute can only do what the statute permits it to do. Well, the Court of Appeal actually said, no, Mr. Goff, I don't agree with you. They said that the IDT, because it has this very broad remit and the remedies that it can offer are so limited, that it must be able to fashion its own remedies. Now, respectfully, I disagree with the Court of Appeal on that. My perspective on it is, if the IDT is challenged by the legislation, the law must change. That's what is done in every other jurisdiction. If the law is updated to reflect the needs of society, it's not that you let's say, okay, well, since it's not there, you must implicitly have the power to do something that's not there stated. But anyway, that was what the Court of Appeal said, that they have this implicit power to fashion their own remedies. And the funny thing about that is that when I had actually taken, on behalf of an employer now, I had asked the ministry to refer a dispute that the employer was having with an employee to the IDT, and the response from the ministry was, there's nothing in the LRIDA that says that the tribunal can order any positive relief in favor of a business owner or a business itself. So when you're creating a body that's supposed to be balanced, but it can only award relief to one of the parties before it, you're building intrinsically into the system that perception of bias. Why is it that an employer can't go there and get an award in its favor other than to say, case dismissed? There's no reason in principle why it can't happen. Let's look at quantum. My colleague, Mr. Stimson, is going to address quantum. The only point I want to say on this is this, that the burden of proof, we all know that in unjustifiable dismissal cases, there's a reverse burden of proof on the employer to prove that the dismissal was justifiable. But what's not so well known is that the burden of proof is where it always is on the person who asserts for every other element. And that includes quantum. So it's not for an employer to go there and say, I think that this is the loss that you have suffered. It's really for the employee to say, this is the loss I have suffered, and these are the steps I've taken to mitigate it. And so when dealing with quantum, what we really want to see from the tribunal is a more rigorous analysis of the evidence of the loss so that we as advisors can tell our clients, this is what you can expect to happen if you go before the tribunal. This is the range of awards that are being given. This is how they worked it out and reasoned it out. And therefore, we think that you're going to come here, between here and here, if you lose. And then the final pillar, final pillar, is be consistent. Admissibility of evidence is one of the things. What you need to do, IDT, is actually tell us what your rules of evidence are. Because we have so many cases where one panel will admit something and the other panel will not admit the other thing. You have a lot of cases where the feeling is that because we're being less rigorous than the court, that the rules can be bent, but it's not always bent equally for both sides. I want to give you just one example. We've already mentioned the Peter Jennings case, which is another landmark case. In Peter Jennings, there was actually no evidence put forward by the worker. The worker did not call any evidence, didn't take the stand. They simply submitted a brief and they put their position and evidence in the brief. That evidence was never tested on cross-examination. When we went to the court and said, that's not really fair because the other side, the employer's evidence, was all tested and in some cases undermined on cross-examination. So why is it that only one party, but notwithstanding that, the court treated with Mr. Jennings' evidence, i.e. the material in the brief, as if it was evidence, and said that the tribunal has the power to consider anything that's put before it, whether it comes in through the stand or not. That kind of inconsistency of approach is not in the interests of dispute resolution. The last 2 points I want to make, when prior awards are not followed, just like with the court, you need to explain why it is the case. Don't simply say, I'm going to distinguish this case without saying why this case is distinguishable, because it then helps us as advisors to tell our clients, to tell them that this is the decision that you're likely to get consistent with other awards which the tribunal has made. What's happening now, unfortunately, is that we're just saying, I heard you say that you mentioned this case, but I think those cases are distinguishable with no explanation. And finally, awards and notice pay. I know that Senator Brown is going to stay here for that. Senator Brown is a fantastic advocate for the tribunal being able to do the illegal. to take onto itself the role of awarding notice pay to workers who haven't gotten it. And at the same time, I don't have a difficulty if it's going to do that, but you also must be able to do the same for employers. So if an employer comes and says, this person got out, left my business without giving me notice, there's no reason why, if we're going to start ordering notice pay to be paid to a worker, that it can't be the same for a business owner. Ladies and gentlemen, that's my time. Thank you very much.
Thank you, thank you. Let me shiver my way back over here, because over there is very cold. All right, so our next panelist is another learned friend. He is a proud father of 2 daughters who keeps him on his toes and his knees. And also a proud Woolmerian? Woolmerian. I'm sorry, I'm from the West. He is a lawyer with over 20 years' experience at the private and public bar, who piles his trade experience, his trade primarily as a civil litigator. His career is best defined by his leadership and service, reflecting a commitment not only to his clients, but also to the broader legal community and the development of the profession. He was admitted to practice in 2003 and joined Hart Muirhead Fatter as a partner in 2012 and has been a litigation consultant with the Attorney General's chambers since 2022. His practice spans civil and commercial litigation, industrial relations, public law, sports law, and conveyancing matters. He rises to the challenge of navigating and resolving complex legal issues, offering strategic advice and representation that consistently aims for solution-oriented outcomes. You may present. I'll just stand here over there too.
We'll stand beside me. I'm getting some company.
Yeah, because over there is two.
My name is Stuart Stimson, and I am pleased to be here. Not an unexpected privilege. And today I have the task of being able to give some criticisms by invitation. I said that on purpose for the planner of this event. So we're talking about all means new ends. Is the IDT still fit for purpose? Anybody may know this vehicle? In 1976, this was the car of choice, Oldsmobile Cutlass. It was cutting edge at the time. We call this car a classic today. And it's important to note that distinction because it's not timeless. We know the difference between the two, right? Similarly, we're looking at a panel, a tribunal that has been in existence for as long as when this was the best-selling car in America. Is the tribunal's procedure classic or timeless? My view is it is not, in fact, timeless because times have changed. And that's because we have a whole new dispensation since 2010 for this tribunal to consider. And it's the majority of what the tribunal does consider. In the last 2 years, 93.8% of the cases that were referred to the tribunal were involving individuals, individual rights, not the classic formulation of collective bargaining. And at the underpinning of the tribunal's process in determining matters must be what? Harmony, maintaining industrial harmony. That's the premise of settlement and resolving of matters. But that definition meant something in a different dispensation. Before 2010, when you only focused on collective bargaining, that framework, you were looking at industrial peace, managing strike action from St. Patrice's father and others like Reg, his father, and a then young, full of hair, Lambert Brown. A radical who didn't have to wear these dark glasses, Danny Roberts. It was to prevent a different focus. Now, in this dispensation, with the majority of the matters being for individual rights, you're talking about dispute settlements. That's your focus. Your focus now is a very different idea of what resolution means. At the heart of that is an examination of, does that old model apply to the lowest common denominator now? What is the majority of our focus? It's not collective bargaining matters, is it? So if we look at that lowest common denominator test, I think we're failing it because of the focus. And the rules themselves were not designed to help the people who are uninitiated in that sort of framework. There are secret rules, properly called undisclosed by design. That's what the rules say when you look at the procedures that were disclosed through an access to information request by someone here. And the effect of those procedures mean that we have the challenge that Gavin spoke about, disclosure. And the ultimate principle, you have to know what you're being mastered by. I'll never forget a colleague of a great lawyer, over 15 years at the bar, between 10 to 15 years, had himself before the tribunal for the first time in a constructive dismissal matter. He didn't know he had to appear first. Good lawyer, well prepared. Where could he find it? He wasn't around at the time when Gavin got the information. It wasn't shared to him. It's a secret. That's a problem. Big problem in terms of dispute resolution is you're going to have a challenge now where the burden of proof in settlement of a dispute between worker and employer, compensation, your termination is challenged. It's not deemed to be fair. Reinstatement is an unlikely consequence. So we see many awards having this dual function of now focusing on compensation, and if you don't reinstate, you get some more money. Familiar with those? What's the challenge here? At the core of this is the money. What's the compensating factor that could result in settlement? And what we have is, according to our rules, the result is the employer who goes first has to prove a negative. He has to prove that you failed to mitigate or that you have mitigated your losses to be able to justify his position. That's a burden that's very hard to prove in this dispensation because of our evolving laws. We now have data protection and civil and human rights in our amendments to our Charter of Human Rights. We have a Data Protection Act. That means access to information is going to be regulated in a far different way. And to that extent, we have a solution that is underutilized by the tribunal. It's provisions under Section 17, which allows it to summon individuals, documents, compel evidence, produce evidence. Speaks to that idea of case management we heard earlier, right? We have a framework where this is not utilized unless there is an exhausted indication that the employer has raised a position that then has to be satisfied, potentially. I'm yet to see it actually become utilized in recent time. I'll give you an example of a cautionary tale. Let's call it IDT 5 of 2024. It's a matter in which you had a worker aggrieved by dismissal. It was done BC, before COVID, and the matter was heard in 2024 as a referral. So that entire period of time, the claim was for timeout. At the heart of this dispute would have been not only the matter of whether the termination was justified or fair, but the core challenge was between the exchange of the parties in their conciliation phase, and certainly as disclosed in their brief to the tribunal, was the matter of compensation. A claim was made for over $13 million for the timeout since termination in 2020. Until then, the company would have indicated, we're happy to settle this matter, but we think it's worth far less because we believe the person was employed elsewhere shortly after termination. So right on the face of a brief which was exchanged was the ability for a tribunal to assess facts and decide, how do I create harmony? It wasn't taken up, was it? No. We had 19 sittings, and the employer was able to bring evidence to support its position that, in fact, there was less than candid positions taken by the worker. The result was that the determination was not fair. There was compensation, there was a resolution, but guess what happened in between? Once the worker had realized that this information was disclosed, good counsel of the worker had filed a claim in the courts, sought injunctive relief for that disclosure, formed a data protection claim, the first to be determined in this country. We now have gotten the award in 2025, but guess what survives? The data protection claim. More cost, more time. Could the tribunal have been able to look at this matter, focus on the issues that were live before it, and say, with some sort of case management, narrowing of issues, you're willing to settle this matter? The ultimate issue is, can we prove you're working or not? Simple. If that had happened and they exercised those powers, the jurisprudence in the data protection may not be advanced, but there could have been harmony through the settlement of that dispute at a much shorter time and less fees for the lawyers. As a consequence, there's an example. This exists elsewhere. Remember, I like solving problems. We have approaches in other jurisdictions. We can look at Antigua and Barbuda. Her Excellency described Trinidad for us, and we have the UK and the ACOS Code. These areas provide all the things that Gavin spoke about. Interestingly, if you took a checklist of them, you'd realize that what I think are the standards for harmonization today would be public procedural rules that are clear and known, mandatory pretrial disclosures. You're forced to have your witness statements. There is a mitigation assessment. You evaluate a case and determine, can I narrow this dispute? Is it as broad as the matter of determination alone, or is it one aspect of it? And if that can happen, your mandate as a swift and efficient tribunal, I don't think you have to be a court. The law, as it currently is formulated, allows that ambit, but are you using it? Will you become timeless or classic? Consequently, there's a need for reform, and those reforms we speak about are in that modality that I just discussed. I'm giving you a teaser, I'm told, and we say, why does it matter? Because the data shows that there's a need. The majority of who you now serve are not from the collective bargaining space. The limitations are real as we've identified them, and the reform is possible. It exists elsewhere. Today's industrial harmony is going to be maintained by procedures that the parties can understand and trust and accept, even if they lose. If it's clear, you have to accept it. So, ladies and gentlemen, the mandate has changed. The machinery must also follow. I thank you.
Thank you, Mr. Simpson. My apologies for not saying your name. I blame it on being cold. So the final panelist is also a learned friend, Mr. Emil Leiber. Mr. Leiber told me I can summarize his in 2 sentences. I'll do 4. Mr. Leiber has been practicing at the bar for over 23 years. He is the former managing director of Don Cox Attorneys at Law, the president of the Jamaica Chamber of Commerce, the first appointed chairman of the Disabilities Tribunal, and a past president of the Jamaican Bar Association. I reached 4 sentences already? He practices in employment law, civil litigation. He also acted for numerous statutory entities in employment and tax matters. I will say no more. Mr. Leiber.
You know, we're at this point in the day where I should ask everybody to stand up and stretch to make sure you're still awake. But I'm the closing batsman, and I'll try to keep you awake for this last section. So I don't often get to say this, but Gavin and I are ad idem. So I will simply expand on what Mr. Goff has introduced, because there is a good portion of overlap. But the principle and concept remains the same, that we are all interested in making matters before the tribunal more efficient. So we first look at, again, the same case management concept, but just to expand on that a bit more. Let me deal with it this way. So the 3 pillars of my presentation have to do with case management, the strengthening the award enforcement of the IDT awards. So as most in the room will know, you have to go to a half-retreat court, which does not result in a direct remedy. It results in a fine, right? If you're the award that the IDT, after 50 sittings, 80 sittings, whatever number of sittings, the IDT hands down an award, your ability to enforce that is unclear at present. And Mr. Goff and I are trying to seek some clarity on that in the Supreme Court as we speak. But, you know, we're not there yet because the judge is still unclear. Right? So when you have stronger compliance, of course, then that also results in a stronger process. Meaning that when people know that if an award is made, this now has the strength of a Supreme Court judgment, and the interest which then that is attracted to that, you don't need to expand the LARIDA any further, right? Because once it is registrable as an award, it's similar in a similar way to an arbitration award. So under Jamaican law, an arbitration award can be registered, and then it becomes a judgment. And once it becomes a judgment, now the Jamaican court system takes over, right? So you have all the remedies that are available as a judgment. Now, one of the reasons why this is important, again, is that when somebody is looking at settlement, they look at their potential exposure, potential liability, and so on, and enforceability. So some employers may well take the view, well, if the IDT makes an award, so what? Right? You can keep trying and so on, but then you have overseas companies who are registered to do business, and the local people out here are not the ones who are making the decisions, right? So, yes, well, luckily we're not all of the inclination of Mr. Moore. So, when you look at these things, and these things were touched on before, so I'm not going to spend any time on them, but expand on the whole pre-hearing conference concept, right? We don't want to make the IDT into a court, but I know, where's Mr. Sangster? You know, so one of, you know, we know for sure that Mr. Sangster will encourage settlement in the first hearing and admonish the parties and you know, push them in that particular direction. And there we go. And it has resulted in resolutions, right? So this is something which potentially could be done in a way that does not utilize the panel of 3. So this is why case management is important, again, to expand on the point. A case management can be chaired by a single member of the tribunal. So rather than schedule 3 members of the tribunal to sit down, to have a discussion, to try and resolve the matter, you then, Mr. Sangster heard me calling his name, so he's now, welcome back to the room, Billy. Right, so you can better schedule the time of 1 person than 3, right? And so when you have this difficulty with dates and so on, then that person now can also give that indication as to potential exposure. So again, we're not making it into a court, but you have this concept where you can get an indication as to sentence. So to touch on what Stuart has said and Gavin has said, when a party knows that this is their likely maximum exposure, you're not binding the panel, right? But when they know that this is their likely sum that is likely to be awarded, because we have had several cases where people come to claim things that's not within the jurisdiction of the tribunal to claim, and they extend the hearing as a result of that. If the party can have an appreciation by somebody who's not making the final decision, because we know you can't prejudge and you can't make any statements that suggest that you're coming to a conclusion. But if you have that session early on in the process where people are clear on what either side is saying, then you're more likely to have that resolution. And it must also be borne in mind that by the time you have gotten to the tribunal, you are at least a year into or more that dispute resolution process in conciliation. So the parties have spoken to each other several times prior to that. So we then have set goals, you know, because anything that gets measured gets done, right? So you know what your average time is from a matter is referred to the tribunal to when an award is handed down. So you create that metric, you have that metric, and you drive towards reducing that turnaround time by various mechanisms. So questions, for example, like the jurisdiction, settling the terms of reference, you know, what are we here about? So again, I had a case recently where the date was fixed, we came, and I raised with the panel, well, this matter is also before the court in relation to a similar issue in dispute, and so therefore this matter shouldn't proceed. The tribunal has ceded, and so on. But again, we took that time to get there and scheduled the hearing dates and so on with the panel of 3 that could potentially have been given to another party, right? And so it is the time of the tribunal is valuable, right? So when it is that you have those hearings before the panel of 3, those should be optimized hearings. Now, to touch on one of the things that Lambert had said earlier, again, where the delay post-award benefits employer, delay pre-award benefits employee, right? Because you have this timeout concept that most awards are based on. So the longer a matter takes to be resolved before the tribunal, the larger the award of the employee should be, right? But again, parties should respect the tribunal's time. They should not come on the morning of the hearing to hear, oops, I can't make it, right? There should be something in the mind of a party that says to them, I should not readily, let's call it disrespect the time of the tribunal, right? Because there is no sanction. If you go to court and you don't turn up at court, you can have the default judgment, you can have the case struck out, and at minimum, costs awarded against you. No, you don't need to introduce a cost regime in order to have some form of sanction, right? Because your power to make awards are at large, you can say, if the employee and the representative keep not turning up, you're going to reduce the award accordingly. It's not going to be a blanket timeout. So even if you find in favor of the employee at the end of the day, there's going to be a deduction. You're going to make deductions for the times that they were not present. Similarly, if the employer is the one that is not appreciating and respecting the tribunal's time, this may result in an enhanced award. And again, I think that will stand up for judicial review because it's measurable and it's reasonable and it's rational and it's something that you tell the parties beforehand so that at the case management point, they can be made aware that this is how we work. You know, again, that point where you disclose to the parties from early on in the process, and you can even just give them a sheet to say, here are the points, and when you're requesting the briefs and things like that, these are the things that you need to be aware of going forward. So all of these things are things that are within the current remit, well, other than the registration of the award, that does require statutory intervention. But a lot of these things are within the remit of the current the tribunal's powers to put in place, right? So again, these things touch on what Gavin had presented earlier. And so when it is that, again, you look at these things, so if you compare other jurisdictions, again, it's one thing to have a conciliation office at the ministry encourage settlement, but certainly I've seen in court where a judge tells a litigant, you are not likely to win this case. The litigant takes that much more seriously than if it is somebody else does, because they give weight to what they view as a determining person making that statement. And so the point of this dispute resolution process is to minimize the disputes that come there. One measure of success is resolving many disputes. Another measure of success is minimizing disputes that go there, right? And one of the ways that you minimize the number of disputes that go there is if people have a structured understanding of what they are facing when they go there and what is the scope of the dispute that will be addressed by the tribunal. And so, in sum, right, again, we'll just speed through, but really where we end up also is things like contempt of court and so on, fast enforcement, greater trust in IDT. So when you look at those, if the IDT were to put in place all of these reforms, they would collectively improve, I would submit, the perception of the tribunal, the understanding of parties, and it would result in a structure that was both more efficient and would be, there'd be a greater respect for the structure by the parties who participate in it. Thank you very much.
All right, so I'd like to thank the panelists for such an insightful and impactful presentations. While I agree with some of the suggestions, I don't with others, and I hope that we take a holistic approach to it, because sometimes, well, personally speaking, sometimes the delays is not because of the procedures, because of the parties. You know, and I feel like I know that there are going to be times when things will come up, but I do believe that some representatives, they abuse the situation and the kind-heartedness of the tribunal. All right, so we'll be taking some questions or comments from the audience. Yes, Mr. Moore. Oh.
Good afternoon again. All right, in response to Mr. Leiber's presentation, I think now is an opportune time, given the powers of the IDT under Section 20, to, given the benefits post-award, to, in its decision, maybe make a provision that provided that this award is not settled within 90 days or reviewed, then it should continue to attract a monthly amount. So that way, it could impress upon the employers, if it's against them, to resolve the matter. Would you agree or you disagree?
I'm not clear if that would stand up to judicial review, because an open-ended principal sum is one thing for interest to accrue, for example, but the IDT would have to set out a very clear basis that would be upheld by the courts to have the principal sum of the award increasing to infinity, you know, because if 10 years pass, you know, we have $2 billion, you know, award, then is that within the scope of the tribunal's powers to, you know, structure an award in that way? So that might be subject to judicial review.
Any other questions or comments?
Yes, yes. No, I'm going to be short, I promise. Really, what? Time me. No, I'm at 5:10. No, seriously. I can't remember your name, sorry.
Stuart Stimson?
Yeah, man, Stuart, yeah. Stuart, I like the imagery with the car. No, I actually like it. But guess what? No, guess what? I like the idea of change, but change with a new reality. But you know, I have a old E46 and an M, but it's the same roads. So that's what I'm talking about. So yes, you can talk about a new changes, but I don't know whether or not we have seen sufficient changes that might warrant it. But it's a good point. The question that really rides me though is, and I've heard it earlier on, about this implication of inequity in terms of what the tribunal awards, because you know it awards compensations to workers, but not to the employers, blah blah blah. I get it. But I remember, let's go to the thing. Why was the IDT designed? The IDT was designed to deal with collective disputes. And the typical person or entity that the tribunal is dealing with is employer and organized labor. The entire framework of the LRIDA, the Labor Relations Code, contemplates a trade union. So here's my question as an attorney. I remember, I don't know how the laws changed, but I remember like Wooks versus Barnard, I remember Taft-Vale and those cases. How do you sue a trade union? Or do you impose? Because the last time I checked, the trade union doesn't have the same kind of stature in law that you could do that to.
Well, it's not about the stature. The trade unions have immunity from prosecution, because you have certain senators like Senator Brown who ensure that trade unions are protected in that way. But I think the bigger point here is understanding that although we understand that the tribunal was set up to give quicker and cheaper access to those who need it. That doesn't mean that it can't also be used by the persons who don't or who have greater resources. Because at the end of the day, if you look at how it was framed in terms of what the definition of an industrial dispute is, it doesn't say an industrial dispute is a dispute that an employee has with their business, with their employer. It doesn't say that it's only a one-sided way that disputes are brought. It is framed and defined in neutral terms, in neutral language, which means that more than simply on paper, the tribunal should be able to settle disputes that either party has, not just what an employee has. And I think the problem that we have here is that it's not appropriate to have a minister indicating that I'm going to send you, the employee's dispute, over the very same thing to the tribunal, but you, the business owner, you must go to court. There is no reason in principle why both parties can't go to the same place to get justice on the same issue.
But you know, you don't answer me though, right? No, you don't have answered me, right? I hear you, but you have, I know, because it's a question I'm asking advice from an attorney. I know when you're talking about imposing certain kinds of, what you call it, financial, monetary kinds of, whatever it is, right? So you impose, I get it that you can impose it on the employer against the worker, against a trade union, but no, the other way around, okay? I get that part. I just still haven't got it. Because I heard somebody raise it earlier on. I had a conversation with John Jr. earlier on about that too. So my thing is simple. If you're saying you're awarding compensation, and you know that, yes, it is, you pay that as part of cost or something like that. I'm just saying, if you were to do that, what kind of framework do you have in law that would allow you to do it within the context of the existing law to a trade union? Full stop. Just help me to understand that.
Okay, let me try and explain that a little bit clearer. There is nothing in the law that prevents the tribunal from making any award of compensation in favor of a union or the organization, the business owner itself.
I hear you, and I'm not going to hug it, but I still haven't got the answer because I haven't seen where it empowers it to do it.
If you were hearing my presentation earlier,
I hear you, but
I'd even gone through
I'm going to yield though, yeah? I've had discussion for other people, but I still haven't got the answer.
Thank you.
Yeah.
I am just going to take a minute
I don't need to argue with him.
in response to the
He's written several books,
repeated, and I'm paraphrasing, statement that the employer cannot seek redress. I have a little bit of a challenge with that particular statement because over and over, employers will say there is industrial action, there is work stoppage, there is a situation that it cannot handle at the local level, negotiations. So I understand what you're saying, that you're locating most of what you're referring to as in respect of individual disputes. But we cannot make our blanket statements because the Ministry of Labor every single day deals with cases where employers come to the ministry to say, the Ministry of Labor, we require your assistance in conciliation. And if those matters cannot be settled in conciliation, the minister may decide to refer it to the Industrial Disputes Tribunal. And if the minister doesn't, the minister normally makes a recommendation for the parties to consider. So I believe that we have to consider the entire lay of the land when we make those statements, because it is not entirely correct.
I'm going to only speak from my experience. I have asked several occasions for disputes to be referred to the IDT, and the minister has, through conciliation officers, has told me to go to court. So all I'm saying is that if it were a case where it could be sent to the tribunal, I would love to know why in 50 years it hasn't happened yet. Okay.
Any other questions? I'm getting a signal for no more questions or comments. We will have to, have another session.
Ladies and gentlemen, I'm going to close, and I'm going to close in less than 5 minutes, because I'm not going to attempt to recap all of what transpired in the last 2 sessions, except to comment generally that I still continue to have the impression that we had a very successful outcome. And the very fact that people maintained an interest, continue to be here, and they continue even to ask questions is an indication of that. And we're not going to exploit it. We're not going to take it any further. I want to thank you on behalf of the tribunal and on behalf of the Mona School of Business and Management for your involvement. Some of the presentations, quite frankly, were absolutely brilliant. Some of them will need some work. And we are going to be in touch with you. And the hope is that over the next year, we will bring those to a level where they can have an impact on policy and we can publish them. And there is scope for, perhaps, for collaboration. I talked about that a little earlier on. There's scope for collaboration. If you found that today, what are the things you discovered? It was that there was an overlap between the way you think about a particular issue and the way another colleague thinks about it, and you want to write jointly, that's fine. That gives you some space to write another paper. But we know you're busy. We're not going to push that, but we would like it. And some of them clearly are in need of development. For example, take the matter of how the IDT works, the absence of, as you suggested, rules of evidence, clearly defined rules of evidence, questions of consistency that you spoke about, the idea of building a case management framework. All of those are things that we really kind of feel it, we there, as we're working, the idea of getting more support, the idea of how the IDT should work now, 50 years after, as distinct from the way it used to work before, the way it should work now, 10 years after, 60 years after when the LRIDA was amended. So generally, really, I think we're on to a good thing. I hope you feel that way as well, those other panelists and the ones who are here. And I hope we can work together to complete the outcome and to arrive at the outcome that we desire. There's something that came across. I just mention it in case you know about it and you have the kind of connection that will make it happen. I don't think I've even said it to Danny. One of my former students who's completing law school told me that there's an internship program. And law students are expected, when they're doing the finals, the certificate part of their program, to go out and do work under the supervision of an attorney. It looks like a glorious opportunity to bring some young person in, treat them as a research assistant, give them some practice on doing the things that lawyers do, and this may be a way of getting some of these things out to us in a expeditious. So I just want to end by thanking you again, thanking everybody, thanking the audience for coming and for staying the course, for displaying the level of interest that you had, and to thank all of you presenters for the work that you have put into it, and express the hope that you'll work with this to bring this whole project to completion. All right? Thank you.